الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لوليه والصلاة على أهلها السلام عليكم جميعا ورحمة الله وبركاته. First of all, uh, I would like to thank iCare for inviting me to present some of my research. And I should say at the outset that this what I'm going to say today comes out of the project or the research that I undertook with Hassan Ansari, and so it's a result of that collaboration. Um, in any case, the fact that iCare invited me here, I'm very grateful for that, and it's really a testament to their graciousness and not the quality of the of the work. So I'm very grateful for that opportunity. And in honor of the month of Sha'aban and what it gave to us, and with the permission of the elders in the community, I'd like to begin with a short poem in Urdu, which is as follows. अक़ीदत पैकर अल्फाज में जब जगमगाती है अक़ीदत पैकर अल्फाज में जब जगमगाती है मुझे लफ्ज़ों से अपने निकहते फिरदौस आती है जनाब फ़ातिमा के लाल हैं जन्नत के शहज़ादे यही वो बात है जो जन्नत को जन्नत बनाती है दुरूद भेजे मोहम्मद व आले मोहम्मद. So to start, I want to mention a academic controversy which has sort of inspired my interest in this issue. In a recent roundtable, which is titled "Feminism and Islam: Exploring the Boundaries of Critique," and published in the Journal of Feminist Studies of Religion in 2016, a well-known scholar, Asma Barlas, criticized what she called, quote, the anti-Quranic turn in the scholarship of some theorists who are also critics of Islamic feminism, unquote. And in this group of theorists, she included Ibrahim Musa, Nasr Hamid Abu Zaid, Kisha Ali, Raja Runi, and Aisha Hidayatullah. The published version of the roundtable includes responses to Barlas by Kisha Ali, Karen Bauer, Amina Wadud, Aisha Hidayatullah, Fatima Sidat, and Yasin Rahman. What's apparent in Barlas's contribution to the roundtable is a deeply held belief in the primacy of the Qur'an for the determination of norms. So, for instance, Barlas observes that fewer than 6, quote, anti-women, unquote, verses, quote, form the basis of both law and scriptural exegesis, unquote. Similarly, with serious hesitation, Barlas embraces Margot Badran's definition of Islamic feminism as an approach that, quote, derives its understanding and mandate from the Qur'an, emphasis on from the Qur'an, and seeks rights and justice for women and for men, unquote. In addition to subscribing to a belief in the primacy of the Qur'an for the determination of norms, scholars engaged in, quote, liberatory hermeneutics, unquote, uphold, quote, the fiction that the text actually provides the norms and we merely discover the norms. And that's a quotation from Ibrahim Musa. While this fiction, what Ibrahim Musa calls text fundamentalism, may be necessary for grassroots activism, scholars like Kisha Ali fear that, quote, in seeking to get things done, they may inadvertently shore up the authority of certain texts, thereby compromising their ability to do paradigm shifting work. Now, a belief in the primacy of the Qur'an for the determination of norms and text fundamentalism are certainly characteristic of modernist and reformist thinkers, for instance, Fazl Rahman and Abdullah an-Na'im. In her contributions to the Roundtable, however, Barlas implies that upholding both beliefs is essential to any authentically Islamic framework. And this would have come as a surprise to Imāmī jurists who debated the value of the Qur'an as a source of information about law. In this paper, I argue that Imāmī jurists' discussions about the value of the Qur'an as a source of information about law furnish significant counterexamples to Barlas's conception of Islam and support aspects of her critics' arguments. In other words, the 14 centuries of exegetical history that Barlas cites in her critique is even more rich and complex than she admits. Imami discussions about the value of the Quran as a source of information about law emerged in broader jurisprudential discussions about the value of non renowned reports for law. Now, very briefly, there are essentially two kinds of hadith. There are renowned reports and non-renowned reports. Renowned reports, mutawatir reports, are those reports which give rise to knowledge, and non-renowned reports are those reports which do not give rise to knowledge. Every hadith which is sahih or hasan or muwathaq, it is a non-renowned report. And for the sake of convenience, when I say hadith today, I mean non-renowned reports, akhbar al-ahad. So the use of non-renowned reports, it posed a problem for Imami jurists because such reports do not give rise to certitude. One of the best discussions of this issue, it's found in Ma'alim al-Usul by Al-Hasan ibn Zainuddin al-Amili, who is known as Sahib al-Ma'alim on account of this book. Now, Sahib al-Ma'alim's discussion of non-renowned reports begins with a familiar definition of the category. What is a non-renowned report? It is a report that does not give rise to the level of tawatur, renown, regardless of the number of narrators. And its nature is such that, in and of itself, it does not give rise to knowledge. Now, it's important here to bear in mind that knowledge means itma'anan an-nafs, which could be translated as certitude as opposed to certainty, and there are some differences. Sahib al-Ma'alim adds that although some scholars claimed that such a report does not give rise to certitude even if it's supported by qara'in, I'll explain what they are in a second, the correct view is that it may give rise to certitude if it's supported by qara'in or circumstantial evidence. Now, itmi'nan an-nafs is a certitude. It's less than the certainty that 2 plus 2 equals 4 yields. And this is something which is important. And the second point is that if you have a report like this, either it can be accompanied by circumstantial evidence or it's not accompanied by circumstantial evidence. If it is accompanied by circumstantial evidence, okay, it can give rise to knowledge. The question is, if it's not accompanied by circumstantial evidence, then can it be used in the context of a legal argument? And let me say something before moving forward about the concept of circumstantial evidence or qara'in. Now, the best way to understand the thinking behind a consideration of circumstantial evidence is to take a classic example. Suppose someone informs you that Zaid has died. The report might be true, it might be false, but you're inclined to believe it because you know that A, Zaid was sick, B, you heard Zaid's family wailing loudly, and C, you saw Zaid's family dressed in black with their collars torn, right? All of those would be circumstantial evidence, and they would give you a reason to accept the report as opposed to reject it. In and of itself, the report might be true, it might be false. As for circumstantial evidence that points to the acceptability of a hadith, Abu Ja'far al-Tusi or Shaykh al-Ta'ifa, he mentions four. One is agreement with the dictates of reason, أحكام العقل or حكم العقل. Two is the conformity to an explicit text in the Quran. Three is the agreement with the renowned Sunnah. Four is agreement with the uniform practice of the Imāmī community. Now, four was especially problematic because it raises the question, when Abu Ja'far al-Tusi says agreement with the uniform practice of the Imāmī community, did it mean the uniform practice of the Imāmī community demonstrated the evidentiary value of hadith as such, or only those hadith that had actually been implemented, and by extension the sources from which those hadith were taken? This is a very significant question. We cannot overstate the significance of this question, but it seems more likely that Shaykh al-Ta'ifa, rahmatullahi ta'ala alayh, he meant the latter. Now, in later tradition, the notion of circumstantial evidence was explained in greater detail. It included a hadith found in many of the original 400 notebooks or jotters of the ashab of the imams. It included a hadith that was repeated in the same notebook with several chains of transmission. It included a hadith that was found in the notebook of one of the group of scholars known as Ashabul Ijma'. It included a hadith found in a book that had been presented to an imam and gained his approval, and a hadith that was taken from a book that was well known among the trustworthy and reliable early community. So, what we have here is essentially a source critical approach to hadith. The problem is that once these early written sources were incorporated into Buwayhid era compilations, it became very difficult to determine the original sources of hadith. And the realization that hadith could no longer be evaluated in this way is what led to the adoption of the fourfold typology of hadith in the 13th century. When we say fourfold typology, we mean the categorization of hadith into four classes: Sahih, Hasan, Muwathaq, and Da'if. Now, as for the question of whether non-renowned reports, akhbar al-ahad, or the vast majority of hadith, that are not supported by qara'in, circumstantial evidence, give rise to certitude, Sahib al-Ma'alim takes the view that in principle, it's possible to establish legal obligations on the basis of such reports. In Islamic law, this is called jawaz at-ta'abbud bi khabar al-wahid aqlan. And moreover, Sahib al-Ma'alim says that other than Ibn Qiba, he doesn't know any Imāmī who believed that it is impossible, who said that it's not possible to establish legal obligations on the basis of such reports. Uh, he attributes this view that it's not possible to Mu'tazilis like Abu Ali al-Jubba'i. And of course, Ibn Qiba was a Mu'tazili before he became an Imāmī. Now, simply because something is possible, remember the first question is it possible? But simply because something is possible in principle doesn't mean that it's pleasing to God. So the next question is whether the lawgiver has actually endorsed the theoretical possibility of establishing legal obligations on the basis of non-renowned reports that are not supported by qara'in. Sahib al-Ma'alim begins by acknowledging the disagreement among Imamis over this issue. So he notes that there's a group of early scholars, including Al-Sharif al-Murtada, Ibn Zuhra, Al-Qadi, Ibn al-Barraj, and Ibn Idris. All of these people held that although it's theoretically possible to establish legal obligations on the basis of ahadith that are unaccompanied by qara'in, the lawgiver, the Shari', never endorsed the use of such reports. By contrast, most later scholars held that he did. Usually in Shi'i tradition, the division between early and later is Abu Ja'far al-Tusi, who died in 1067 of the common era. So Sahib al-Ma'alim endorses the latter view, the view of the later scholars, and then he proceeds to offer evidence in support of it. And he offers four pieces of evidence. Ayat al-Nafar, Ayat al-Naba, and then the common practice of early Imāmīs, and the closing of the gate of ijtihad. Now, all four of these are, require a very detailed unpacking. We are not going to unpack either one or two or three. We're going to focus on four right now. Um, and again, for the sake of time, I'm not going to mention Sahib al-Ma'alim's discussion of either one of the ayahs of the Qur'an, but I do want to point out that his discussion of ayat an-Nafar in particular, right? وَمَا كَانَ الْمُؤْمِنُونَ لِيَنْفِرُوا كَافَّةً. His discussion of this ayah in particular is extremely detailed, and it may be the first time since Allama Hilli that this verse was discussed in such depth and in connection with the question of akhbar al-ahad in a work of usul al-fiqh. This is not my observation, this is the observation of Hasan Ansari. Um, Now, let me talk about three and four, not just four. So regarding the common practice of Imāmīs, Sahib al-Ma'alim argues that Imāmīs who lived in the time of the Imams or shortly thereafter, they commonly narrated and recorded non-renowned reports. They concerned themselves with who related a particular report, and they drew a distinction between trustworthy and untrustworthy individuals. This was the common practice of each generation in the time of the Imams, and there is no evidence that anyone from that era opposed it. Furthermore, although we have plenty of ahadith from the Imams, we don't have a single hadith that opposes the evidentiary value of non renowned reports. This is Sahib al Ma'alim's argument. Now, to support his argument, Sahib al Ma'alim quotes the following from Allama's Nihayat al Usul, which is one of the most important texts on jurisprudence. Allama says, as for Imamis, the Akhbaris among them do not rely in matters of the roots of religion and its branches on anything except Akhbar al-Ahad, transmitted from the Imams upon whom be peace. The Usulis among them, like Abu Ja'far al-Tusi, may God have mercy on him, and others, are unanimous in their acceptance of the Khabar al-Wahid, which is just the singular of Akhbar al-Ahad. No one denied it except for Sharif al-Murtada and his followers due to a doubt that they had. Now, additionally, Sahib al-Ma'alim notes that al-Muhaqqiq al-Hilli related the same argument in his well-known and very important book Ma'arij al-Usul from Abu Ja'far al-Tusi. In fact, Al-Muhaqqiq went further by claiming that implementing Akhbar al-Ahad unsupported by circumstantial evidence, this is a matter of consensus among Imamis. And as Muhaqqiq notes, when early Imamis were asked to justify a fatwa, a legal opinion, they relied on what was related, recorded, transmitted in their reliable sources, and this satisfied the one who was seeking an explanation. Of the arguments that Sahib al-Ma'alim proffered in support of the acceptability of non-renowned reports, the fourth one, the closing of the gate of knowledge, is noteworthy because it was a new argument. And this argument can be formulated as follows. Excuse me. The gate of certain knowledge, al-ilm al-qat'i, and remember that ilm and qat, they mean itma'anan an-nafs, certitude. The gate of certain knowledge to the directives of the sharia that are not known necessarily, lam tu'lam bid-darura, from the religion of the school of the house of the Prophet, peace be upon them, in times like ours, is definitely closed, since what exists of the indicators of the law only gives rise to supposition, dhan, due to the loss of the mutawatir sunnah, the renowned sunnah, the severing of any way to be apprised of a consensus other than a quotation in the form of a non-renowned report, the clarity of the fact that the principle of exemption, asalat al-bara'a, only gives rise to supposition, and the fact that the significance of the Qur'an is suppositional. If the gate of knowledge is proven to be closed in the matter of a legal directive, hukum, shar'i, then one's obligation in the matter definitely must be determined by way of supposition, dhann. Reason dictates that if supposition has several aspects that differ with respect to strength and weakness, then turning away from the strong and to the weak, this is repugnant, qabih. There is no doubt that there is no doubt that one obtains a kind of supposition from many non-renowned reports that one does not obtain from any other indicator of the law. So it's incumbent to prioritize acting in accordance with them. Now, this is a mouthful, but we can summarize it as follows. The passage of time has made it impossible to obtain certitude about the majority of legal directives, ahkam shar'iyya. What we have left are indicators that give rise to supposition, dhann. One could argue that the renowned Sunnah, consensus, ijma, the presumption of exemption, salat al-bara'a, and the Quran all provide ways out of the conundrum. So we begin with that we have a problem here because we have no way to know the law except for no non-suppositional way of knowing the law. Somebody can argue back and they can say, hang on a second, that's not true. We do have some ways. We have the renowned Sunnah, we have the presumption of exemption, salat al-bara'a, we have we have the Quran, and we have consensus. Sahib al-Ma'alim's response to this hypothetical objection is that much of the renowned Sunnah is lost, right? And we come to know about it. How do you know that an ijma has taken place? It's communicated to you through a report. So we come to know about a consensus via a non renowned report. The presumption of exemption can only produce supposition, and the significance of the Quran is suppositional. The Quran is dhanni ad-dilala. Obviously, Muslims did not doubt the provenance of the Quran, but the Quran was said to be, with respect to its significance, dhanni ad-dilala. So, having ruled these things out, Sahib al Ma'alim concludes that we have no choice but to rely on supposition, or we can pretend like we have no obligations before God, which is false. In other words, we have ilm ijmali of taklif. We have some general idea that we have some obligations before God, but we don't know exactly what they are. Now, of course, we can know some ahkam because they're evident. Wujub as-salat, right? Everybody knows the ritual prayer is obligatory. So we can know some, but Sahib al-Ma'alim says this is only true in a very small number of cases. In the vast majority of cases, we have to make do with evidence, or you can say indicators, uh, I mean adilla, that only give rise to supposition. The other really important point is that any particular supposition, any particular dhan, it can be weak or it can be strong. And reason dictates that a strong supposition should be prioritized over a weak supposition. Why would you prioritize a weak supposition? So although hadith do not give rise to certitude, in many cases, they give rise to supposition that is much stronger than what we can glean from other indicators of the law, including the Quran. Therefore, there's no basis for prioritizing the text of the Quran over hadith. So, for example, on what basis does one accept uh, universal statements in the Quran? For example, ahallallahu al-bay'a, umumat al-Quran. God has made commercial transactions lawful. On what basis does one accept that? On what basis does one accept adilla lafdhiya, meaning, for example, aqim as-salata, it's an imperative verb. You should establish the prayer. What is the meaning of the imperative verb? This is part of that discussion. On what basis do you accept these things, but you don't accept non-renowned reports? So the genius of Sahib al-Ma'alim, and he was a genius. When we talk about, the history of the tradition, and we mention those people who are kind of they, you know, the entire tradition becomes embodied in certain people. Uh, Sahib al-Ma'alim, in my view, would be one of them. Oftentimes, when you read Ma'alim al-Usul, you want to praise him in a way that you only are used to praising people like Abu Dhar and Miqdad and Salman. In any case, by framing the issue in terms of evidentiary value, and that's the key here, is that Sahib al-Ma'alim frames the issue in terms of hujjiyah, in terms of evidentiary value. By doing this, Sahib al-Ma'alim was able to demonstrate that hadith, while problematic in certain respects or in some respects, are often the best evidence available to us. And this move was justifiable because while Muslims generally did not doubt the provenance of the Qur'an, right, the significance of the Qur'an was said to be suppositional. If all the evidence available to us is suppositional, then there's no basis to prioritize prima facie the Qur'an over other evidence. Now, to help us think through this argument, Sahib al-Ma'alim responds to a series of theoretical objections. The first of which asks us to consider the law of evidence. So, in some cases, Sharia requires the testimony of two eyewitnesses. Such testimony gives rise to supposition. We all know that just because somebody testifies to something doesn't mean that that thing is true, right? So, that testimony that's given in a courtroom by two eyewitnesses, this gives rise to a supposition. It's conceivable that the testimony of one eyewitness could give rise to an even stronger supposition, right? For example, the testimony of one expert eyewitness, maybe it's more credible than the testimony of two eyewitnesses who are not experts. So if a strong supposition outweighs a weak supposition, then a judge should be allowed to issue his verdict on the basis of the testimony of one eyewitness, one expert eyewitness, right? Um, excuse me, he should be allowed to issue his verdict on the basis of the testimony of one expert eyewitness. But we know that that is not the case. We know that that's haram in cases where the Sharia requires two expert eyewitnesses. It would violate consensus. So this then is a counterexample to the claim that a strong supposition always outweighs a weak supposition. This is what the person arguing against Sahib al-Ma'alim says. Now, Sahib al-Ma'alim responds to this argument, this counter argument. He says, the law of evidence is not based on supposition. Rather, the testimony of two righteous eyewitnesses is itself dispositive. The lawgiver has not asked us to weigh the relative value of testimonies, right? And then choose the one which produces more certainty. The lawgiver in this case has instructed us to follow a specific procedure, right? Similarly, one does not have to obtain some level of supposition or certitude from the fatwa of a mufti, right? For the fatwa of the mufti to constitute a dispensation for you, a rukhsa for you, isn't that you don't have to obtain some level of certitude about it. Or another example, if that one is unclear, is the confession of a defendant. If when a defendant confesses, does that give rise to some level of or are you charged with evaluating the level of certainty to which that confession gives rise? No, the confession itself is dispositive. So both of these cases are based on the fact that the lawgiver considers those things evidence. And we know that by way of consensus. Neither do we need to be certain. Another example is that you don't need to be certain that the sun has reached its zenith to know that it's time for the Dhuhr prayer. It's sufficient to rely on certain indications that the sun has reached its zenith. And in this case, Sahib al-Ma'alim appears to be drawing on the Al-Sharif al-Murtada's discussion of the meaning of legal reasons, al-asbab or al-shurut al-shar'iyya. And again, this is not my observation. That that point is the observation of Hasan Ansari. In any case, those indications are dispositive in and of themselves. There's no question of certitude or lack thereof. And cases like this are exceptional precisely because we have been instructed to follow a specific procedure. We have not been instructed to weigh levels of certitude. By contrast, reports, akhbar, akhbar al-ahad in particular, are fundamentally different. Akhbar al-ahad are evaluated as indicators of legal obligations, and our knowledge of these obligations is suppositional. It's in our capacity as individuals obligated before God, mukallaf, that we are asked to act in accordance with supposition. So if a supposition is strong, then reason dictates that it be prioritized over a weak supposition. Now, this is the first objection. The second rhetorical objection is based on the distinction between the type of supposition that one obtains from akhbar al-ahad, from non-renowned reports. It's based on the distinction between that kind of supposition and then the kind of supposition that one obtains from the prima facie meaning of the Qur'an, zahir of the Qur'an. The kind of supposition that you obtain from the zahir of the Quran, it's not an ordinary supposition. Why? Because of an important presumption. What's that presumption? The presumption is that it is unconscionable for a wise lawgiver to use expressions that prima facie mean one thing while intending something else without providing some indication that the prima facie meaning is not what is intended. In other words, in the absence of evidence to the contrary, a wise lawgiver means what he says. So, while akhbar al-ahad and the non-renowned reports and the prima facie meaning of the Quran both give rise to supposition, they are not analogous because this presumption is not operative in the case of non-renowned reports. Excuse me. The prima facie meaning of the Quran gives rise to a special type of supposition, dhann makhsus. Therefore, it's acceptable, whereas non-renowned reports are not. Now, before we move on to Sahib al-Ma'alim's response, I want to pause here and note the following. What makes the Quran legible is the fact that God is Hakim. In other words, a theological claim, and I would argue a methodology, but let's just stick with the theological claim. A theological claim is logically prior to the Quran. And we should bear this in mind when we consider the question, what does the Quran mean? Right? What does the Quran mean in the absence of the presumption that the A, God exists, B, God is the speaker of the Quran, C, God is Hakim. Um, Sorry, I switched B and C. You should reverse those. In any case, so let's go back to Sahib al-Ma'alim's response to this objection. Sahib al-Ma'alim argues that, first of all of the Quran's directives are oral speech, or sorry, not oral, oral speech. Khitab al-mushafaha. Let me find this. Okay? Excuse me. Which is particular to those who were present at the time of the address. Now, this is a sentence that, if you've ever heard me speak before, I use it very frequently. Um, the credit for this sentence goes to my colleague, Dr. Sam Boyd. But the point of this sentence is that I only kiss Cubs fans. Most of you are in London, so I guess we would say Manchester United. I only kiss Manchester United fans. Um, if you say that, most people will understand that you mean you don't kiss the fans of, sorry, I don't know anything about soccer, so Manchester United is the only team I know, so I'll make up a team. That you don't kiss the fans of Barcelona and you don't kiss the fans of, uh, I don't know, Netherlands. um, that's not what this sentence means, right? In this sentence, only is an adverb modifying the verb kiss. So what the sentence means is you don't high five the fans of Manchester United, you don't hug them, and so on and so forth. Now, that would be the kind of meaning of the sentence if you analyzed it grammatically. But the point is that when this sentence is spoken to a group of people, everybody knows that that's not what it means. What it means is that you don't kiss the fans of Barcelona and Netherlands. Okay, so the point is, Sahib al-Ma'alim's point is that the Quran is khitab mushafaha, and it's particular to those people who are present at the time of the address. If you want to extend these directives to subsequent generations, you need additional evidence. And we have two pieces of additional evidence to substantiate the extension. One is consensus, and two is the principle of necessity. So, قضاء الضرورة باشتراك التكليف بين الكل is the technical way. So, our ability to cite the text of the Quran ultimately rests on these two indications, amarat, that and these indications give rise to strong supposition. Given that non-renowned reports are also indicators that give rise to strong supposition, or indications that give rise to strong supposition, they should constitute evidence too, meaning that there is no basis to draw this distinction between the prima facie meaning of the Quran and the non-renowned reports. So Sahib al-Ma'alim's point is that the question of non-renowned reports is not simply a question of accepting or rejecting non-renowned reports or hadith. If you reject hadith because they do not give rise to certitude, then on what basis will you adduce the Quran, given that the Quran does not give rise to certitude either? Rejecting hadith while adducing the Quran entails an arbitrary acceptance of some suppositions. And in this way, rejecting hadith is shown to be extremely problematic, because doing so closes the door to law. And reframing the issue in this way was Sahib al Ma'alim's major contribution to the discussion. It's the reason why we remember him, or one of the reasons why we remember him in the tradition. He made it extremely difficult to argue against the use of supposition, dhan, and akhbar al ahad. Um, the other thing that we should say is that Sahib al Ma'alim's arguments, they spawned fervent debate well into the modern period. And as a result of this debate, jurists came to wonder whether knowledge of the Quran was even necessary for law. Do you need to know the Quran to be a faqih or a mujtahid? Al-Fadil At-Tuni, who dies in 1660, he surveyed these arguments in a very important book called Al-Wafiyah. Uh, Now, it's very important for you to note that Al-Wafiyah was a curricular text for decades, and there are several noteworthy commentaries and super commentaries on this book, and it formed the basis of advanced discussions of usul al-fiqh, jurisprudence, in the 18th and the 19th centuries. So it's not some marginal text. It's a very, very important central work. Okay? Um, in his discussion of the qualifications of a mujtahid, after establishing the need for usul al-fiqh, jurisprudence, Al-Fadil At-Tuni addresses the question of whether a mujtahid is required to know the meaning of Quranic verses pertaining to law. As Tuni notes, the prevalent view is that there are around 500 verses of the Quran. So there's approximately 6,600 verses of the Quran. Approximately 500 of them pertain to law, which are typically known as ayat al-ahkam. After quoting three hadith indicating that a portion of the Quran pertains to law, and observing that one obviously has to know these verses to derive law from them, At-Tuni presents the following objection. And this is either a direct quote or a summary of Muhammad Amin al-Astarabadi. And again, the fact that the fact that when Atuni cites this, he's quoting Astarabadi. This is an observation which should be attributed to Hasan Ansari, not to myself. Uh, excuse me. So what does he say? He says, it has been mentioned in hadith that only those addressed by the Qur'an know it, and it's not permissible to interpret the Qur'an according to one's opinion, as At-Tabrasi and others related. What Al-Kulaini related in the section on conflicting hadith indicates the same purport. And in the exegesis attributed to our Lord and our Master Abu Muhammad al-Hasan ibn Ali al-Askari, alayhi salam, it says, as for one who spoke about the Quran according to his opinion, even if he happened to be right, he was ignorant in taking the meaning from those who are not worthy of it. And the entire hadith is long. The quote continues on the next page. In Majma' al-Bayan, At-Tabrasi said, know that the hadith is sahih from the Prophet sallallahu alaihi wa alihi wasallam and from the Imams alayhimus salam who stood in his place, according to which interpreting the Quran is not permissible except with a sahih hadith and an explicit text. Additionally, Al-Kulaini, Ali ibn Ibrahim al-Qummi, and others related many narrations indicating that there are many alterations, taghyir, and substitutions, tabdil, in the Quran. Based on these two possibilities, it is not correct to hold fast to the Quran for the injunctions of the Sharia as long as there is no explicit text that is sufficient. Therefore, knowledge of the Quran is not among the things on which ijtihad depends. Okay, so there's 2 points here. First, the argument that Atuni is citing, there are 2 points. First is that since only those to whom the Quran is addressed understand it, you can't derive law from it. It's not addressed to you. To understand the Quran's legal injunctions, you have to refer to the hadith of the Imams to whom the Quran is addressed. The second point is that because the Quran has been altered in some fashion, you cannot adduce it in a legal argument. Therefore, given that the Quran, knowledge of the Quran is superfluous to the derivation of law, which ultimately rests on hadith, a mujtahid does not need to know the verses of the Quran that pertain to the law, and this is a well-known akhbari thesis. Okay. Now, how does Al-Fadil At-Tuni respond to this objection? At-Tuni gives 4 counter-arguments. First, with regard to the notion that the knowledge of the Quran and its interpretation is restricted to the Imams, At-Tuni says, okay, but that does not mean that speech should be understood in a way that conflicts with its apparent meaning. For example, there's no doubt that we can know God is one based on the apparent meaning of verses such as Qul huwallahu ahad and your God is but one. And there's no doubt that we can know that prayer, in quotation marks, and the quotation marks are important here, there's no doubt that we can know that prayer is required based on the apparent meaning of aqimis salata, establish the prayer. And the why in quotation marks? Because the word prayer requires some elaboration. It's unclear, but whatever it means, you're required to establish it. Moreover, in every age, jurists have adduced verses of the Quran. This is the practice of the Imāmī ulama. Ibn Babawayh's Man la yahduruhu al-faqih is filled with examples, especially in the chapter on inheritance. And there are innumerable examples of the Imams adducing verses of the Quran to prove something to their followers. So the point is that the practice of the Imams and the practice, the Sunnah of the Imams and the Sunnah of the or the practice of the Imami jurists demonstrates that at least some of the Quran is in fact comprehensible. Before moving on, I just want to note that Tuni, although he responds, he also concedes a lot to the argument, right? So look at the ayah. He said, "Qul huwallahu ahad," right? And even in the case of aqim as-salata, establish the prayer. The question of what the prayer is not part of what he's saying. He's just saying that whatever the prayer is, you are commanded to establish it. So he has conceded a lot, although he disagrees. So the second counter argument offered by Atuni, he says that what is restricted to the Imams is knowledge of the totality of the Qur'an, kull al-Qur'an, right? The third counter argument is that we have hadith that conflict with the hadith about knowledge of the Quran and its interpretation being restricted to the Imams. So, for example, we have very well known hadith at the beginning of Al Kafi, which instructs believers to compare hadith to the Quran and take whatever conforms to the Quran and reject whatever conflicts with the Quran. According to Tuni, there are so many hadith with the same meaning that it rises to the level of tawatur. If it were true that knowledge of the Quran could only be obtained from hadith, it would make no sense for the Imams to instruct people to compare hadith to the Quran. Now, of course, you can go back and read what Al-Kulaini says after mentioning this principle. He himself acknowledges that very few um, uh, uh, um, conflicts can be resolved by resorting to these principles. Now I'm because I don't have the page of Al Kafi in front of me now. I'm questioning whether my memory is correct, but hopefully Sheikh Alex or somebody else can check. Finally, so regarding the notion that the Quran has been altered in some fashion, Atuni says that most scholars don't agree with this. Most scholars don't agree that the Quran has been altered in some fashion. In fact, the vast majority of Imāmī scholars didn't believe that. But moreover, even if one accepts it, there are hadith stating that it's permissible to act upon the Quran as it exists until the rise of the Qa'im. Ajjalallahu ta'ala farajahu sharif. So ultimately, Atuni concludes that one can adduce the Quran in law, but, and this is the key point, he acknowledges the strength of counter arguments and concedes, in my view, a great deal to those counter arguments. So the point is that by the end of the 17th century, it was no longer possible to simply assert the primacy of the Quran for the determination of norms. If the primacy of the Quran could be established at all, it would be an uphill battle. So while Imāmī jurists and the theorists whom Asma Barlas criticized approached the Quran from different directions, they arrived at conclusions with at least one important similarity. Contrary to what Barlas implies, disputing the primacy of the Quran did not create insurmountable theological problems for these jurists. It led them to rethink, perhaps even recover the essential nature of the Quran. Barlas's criticisms of her colleagues appear to spring from a desire to preserve the status of the Quran as a sacred text that has a sanctified relationship to God. But, at least for Imāmī scholars, this did not mean that the Quran is necessarily a book to be read in the conventional sense of the word read. In fact, one could argue that the Quran is not simply or even primarily a source of information. It presents itself first and foremost as a guidance for those who are mindful of God, those who believe in the unseen, establish the prayer, and spend out of what we have provided for them. Surah Baqarah, Surah Mubarakah Baqarah, verse 2 to 3. I always joke in the classes that I teach that it doesn't say that ذلك الكتاب لا ريب فيه هدى للناطقين باللغة العربية. It doesn't say that this is a book in which there is no doubt containing guidance for those people who understand the Arabic language. So this, it seems to me, is an understanding of the Quran that is not entirely dissimilar from the divine human discourse against which Barlas inveighs. Now, we don't have time, but one could also mention the notion of Jari, which is found in Faiza Kashani's As-Safi and features prominently in the modern commentary Al-Furqan by Muhammad Sadiqi Tehrani. Perhaps more than other Muslims, Muslims devoted to Ali alayhi salam should be suspicious of the idea that the Quran says something. because Haider Karrar is reported to have said, هذا كتاب الله الصامت وأنا كتاب الله الناطق. At Siffin, Imam Ali, he said, this is the silent book of God and I am the speaking book of God. So what Sahib al-Ma'alim demonstrates for his reader is the grave consequences of rejecting hadith in toto. If you reject hadith because they do not give rise to certitude, then you have no basis to cite the Qur'an. Citing the Quran while rejecting hadith entails an arbitrary acceptance of some suppositions. And this is an important lesson for Muslim modernists and reformers who advocate scripturalism. If you wish to consider the Quran as evidence, you must also consider the hadith as evidence. And this is, you know, the Quran and the hadith are, as the Prophet, he said, they are inseparable, which adds another layer of significance to the meaning of hadith thaqalain, which is the book of God and my family shall never part ways, which is where the talk takes its title from. Finally, even if we reject the primacy of the Quran for the determination of norms, I don't think that diminishes the value of the Quran as guidance. Hudan lil muttaqin. As the great Indian poet Ghalib said, Go haat ko jumbish nahi aankhon mein to dam hai. Go haat ko jumbish nahi aankhon mein to dam hai. Rehne do abhi saagaro meena mere aage. Though my hand is lifeless, I can still see. So let the chalice and flagon remain before me. Thank you very much. Wassalamu alaikum wa rahmatullahi wa barakatuh.
Well, thank you very much, Professor Aun, for that enlightening and comprehensive lecture on this topic. I feel like there's a huge amount to discuss here, and possibly we need to think about arranging a follow-up at some point. But let me just extend, my appreciation on behalf of ICA and our viewers for you sharing this research with us. We already have some questions coming in. So if any of the viewers do have questions they would like Professor Aun to answer, please post them in the chat. There are a couple have come through already, and a couple have come through by other means. So first of all, I think let's address the questions from the YouTube chat first. So question one is not the Quran a source of guidance to ordinary Muslims? I think the questioner is asking for the views of these Shia scholars in the Shia tradition. Is the Quran not a source of guidance to ordinary Muslims? And also then, if we take the view, so this is question two, if we take the view that Quranic understanding is restricted to the Imams, then what about regular believers? So there's two questions there, I suppose, and both on a similar theme. Would you care to address those?
Yeah, I mean, very briefly, I think in order to address the question in a more detailed way, we would have to talk about what wahi is, which is a very important conversation and a very important discussion. But briefly, we can say that the Quran can be a source of guidance for ordinary Muslims without it being something that one can adduce to derive, legal directives from. Um, the Quran has other kinds of ways of, we can say there's affective content in the Quran. The Quran can move your soul in a particular direction. And these are all ways that are not within the scope of what we would call text processing. So that's what I would say to the first one. The second is, if the Quranic understanding is restricted to the Imams, and what about regular believers? Again, I think my answer to the first question applies here too, that people can obtain guidance from the Quran, but guidance is not the same thing as text processing.
So to almost reformulate your answers there, what you're drawing a distinction between is the Quran as a book of guidance and the Quran as a source of law. So all of the debates that you've mentioned, um, involving Sahib Ma'alim, Fadl Tuni, Amin Astarabadi, and other sort of medieval Imāmī thinkers, these debates are about using the Quran as a source for law, not necessarily using the Quran as a source for spiritual guidance. So from a legalistic perspective, they're saying that you cannot refer to the Quran as a source of law in isolation from the Hadith, but of course they're not denying that the Quran is indeed a guidance for people, in the fuller in the fuller sense.
Yeah, I mean, let's clarify something. The Quran, the idea that the Quran is not addressed to ordinary believers, this is a minority view. This is a view which is attributed to um, the Akhbaris. The first part of the discussion before we came to Fadilatuni has to do with, responding to the idea that you can avoid uncertainty by referring to the Quran. Sahib al-Ma'alim's point is that no, you cannot, there's no way around uncertainty, whether you cite the Quran or not. And moreover, the Hadith in many cases provide you with greater certainty or certitude than the Quran does. Um, so it's more of a critique of the idea. Sometimes such people are called Qur'aniyun in the contemporary Muslim world. It's a critique, or I view it. I mean, Sahib al-Malim wasn't necessarily critiquing them, but I view it as a critique of that idea. Um, so the second part of it about the Akhbari thesis in particular, it's not, the reason I brought that up is because I wanted to say that although Fadil Tuni is not an Akhbari, he's an Usuli and he's very critical of the Akhbaris. But my point is that he acknowledged that it wasn't as straightforward as, you know, contemporary scripturalists imagine it to be. Does that clarify? Is that
Yeah,
clear? Yeah.
yeah. Thank you for drawing that distinction. I think that's helpful. And when you were actually explaining this, it sort of put another question to my mind, which I'll ask now if our viewers are okay with that, which is, this view necessarily, so this idea that the Quran can only be accessed through the Sunnah or through the tradition, is this view um, necessarily exclusive to Shi'i thought, or are there similar or parallel views found in the Sunni tradition as well? Are you able to speak to that at all?
No, I can't. I could. I mean, I could say something, but I try my best to avoid speaking about things that I don't have some degree of competence in, and Sunni tradition is not one of the things I have competence in.
No. Well, thank you all the same for your humility. Um, we have another question. Um, so question 3, does dhalika in Surah Al-Baqarah verse 2 really mean this book or that kitab? And kitab doesn't truly mean book, but divine decree or divine writing. So this perhaps is, I think, more of a question about the translation of the verse. Would you care to address that?
I don't have any comment on that other than to say that, of course, the Quran exists in three modalities. One is the Lawh, which is Kitab, the kind of origin of the book, then the Quran as a recitation, and then obviously the Mus'haf. And so, yeah, I mean I don't see why that couldn't be accommodated here. But we just went through a long discussion about not offering personal interpretation of the Quran. So, yeah, I wouldn't say anything more than that.
So a chance to apply what we've learned in today's lecture. Very good. um, question 4 is, the main objection modernists and academics have to the Hadith is the historical unreliability of it, whereas they have far more confidence in Quranic historicity. Do you have any thoughts on that?
I don't agree that academics, I think actually one of the, you can say it like this, that there's a spectrum of attitudes towards hadith in contemporary historical scholarship. on one direction you might have what you could call a sanguine approach, and on the other side you would have a radical skeptical approach. And I think the radical skeptical approach has been marginalized over the last whatever 20 years, something like that, as a result of Harold Motsky and other people who have applied that same method. I believe you had a speaker here a few weeks ago who applied that method to the codex of Amir al-Mu'minin. So I don't think it's correct. In fact, I think that the burden of proof has significantly shifted. It's not enough now to simply say that the all of this material is made up. I think at the very least, that claim has to be justified. Um, and then do they have far more confidence in the Quran's historicity? I mean, some do, some don't. You know, I think I haven't read some of the more recent scholarship on the history of the text of the Quran. Obviously, we have the studies of Bihnam Sadeghi, um, but it's not the history of the codex. We can say is not something I can speak with any degree of competence on.
I mean, of course, there were also hyper skeptical academics with regards to the historicity of Quran. I mean, John Wansborough, although his views are quite dated now, there was a time when it was very fashionable to suggest that the Quran was not a text revealed in 7th century Arabia, but rather a text cobbled together in 9th or 10th century Baghdad. And before anyone suggests that that view is truly gone, there was, I think, in the last decade or so, there was what was called the Syro-Aramaic reading of the Quran, advanced by the pseudonymous academic Christoph Luxemburg, which again sort of was widely discussed in academic circles. So I think there is, it's important to note that we can perhaps draw a distinction between modernist Islamic thinkers who assume the historicity of the Quran, who accept the historicity of the Quran, but there are hyper skeptical academics who would deny the historicity of the Quran as well. Of course, the recent research done by Angelika Neuwirth in Berlin on the history of the Quranic manuscripts is, rapidly making that position, untenable. But I think it's important to note that when we talk about sort of academics, there isn't this sort of monolith of academics who all believe the same thing when it comes to Quran and Hadith. But if I could just, before we move on to the next question, if I could ask a follow-up question to question 4, because this is, especially in Shi'i circles, it's quite this is something that's quite often thrown out, the idea that the majority of the traditions contained in Al-Kafi are unreliable or inauthentic. Is that something that would have been accepted by the classical scholars that you're mentioning? Is that how they would have looked at Al-Kafi? How would they have approached that question?
No, certainly not. And that has everything to do with um, you know I'm trying to think of a specific quotation that I should know off the top of my head, but
Is this the other?
Fakhruddin at-Turayhi, there's a sentence, if I remember correctly, where he says that some majority of the hadith in Al-Kafi are not sahih, but immediately after that he says that, but it doesn't matter because they are mahfufa bil qara'in. I can't remember the sentence off the top of my head, but the gist of it is that what sahih doesn't mean authentic. And I think this is something that people should understand. Sahih is a technical term it's a technical term of art. And it means there are different definitions of it, but it's a technical term. Uh, for example, Asharif al-Murtada, when he was saying that akhbar al-ahad are not acceptable, when he was saying that non-renowned reports are not acceptable, for him, many of the hadith, perhaps most of the hadith in Al-Kafi were mujma alayhi. They were hadith that were subject to the agreement of the community. They were hadith that were not ahad, were not non-renowned because they were accompanied by qara'in. And we went through some of what those qara'in could be. So no, that's there was, yeah, I should stop there. I think that's enough.
No, not at all. Actually, I was going to ask yet another follow up, because I think there is this notion out there, and that has been popularized, that there is that in throughout the history of Shiism, there's been a fundamental tension between uh, so-called rationalist theologians and traditionalists, which that there is some evidence for disagreements. For example, you have Sheikh al-Saduq's i'tiqadat, and then Sheikh al-Mufid's famous correction or tashih of those i'tiqadat, and there are disagreements about the use of riwayat or traditions in establishing core theological belief. But I find it really interesting that Sharif al-Murtada is, I mean, you could say he's the poster boy of the rational in that period. I mean, even more so than his teacher Sheikh al-Mufid, certainly more so than his student Sheikh al-Tusi. Sharif al-Murtada is seen as sort of like this extremely rationalist, almost universally Shi'i theologian, and to him has been attributed the view, wrongly in my opinion, that that all solitary, what we call solitary reports, are not to be accepted. But so you're saying that from Sharif al-Murtada's perspective, the contents of a Kitab al-Kafi by Khomeini, which were thought to represent the opposite to the rationalist trend. I mean, indeed, one of the points Andrew Newman makes in his book on Hadith as discourse, the formative period of Twelver Shiism, Hadith as discourse between Qom and Baghdad. One of his main points is that Khomeini composed al-Kafi in order to respond to the rationalist theologians of Baghdad and to establish traditionalism. But you're saying then that Sharif al-Murtada more or less looked at al-Kafi as broadly representative of the Shi'i tradition and reliable in its material. Would that
Remember,
be?
remember, we're talking about law, right? The best attested hadith in the tradition are those hadith which pertain to law. So whenever you find those discussions, we're talking about legal hadith, and then the hadith related to ibadat are even better attested than the hadith related to other things. So, you know, um, you have to separate these two things out, because, as Hussein ibn Abd samad says in Usul al-Akhyar, the hadith related to theology are in some sense superfluous because they're not adduced. You can't adduce a hadith to establish a theological claim. And the hadith related to ethics are also in some sense superfluous because you know these things already too. So the hadith which need to be scrutinized the most are the legal hadith. And so because of the need to scrutinize them, they, not as much attention is paid to the other hadith. So I can't speak on, the hadith related to theological claims, for example, usul al-kafi as opposed to furu al-kafi. I can't speak on that. Um, but one thing you can say is that if just because something is mahfufa bil qara, so just because something is accompanied by circumstantial evidence in the time of al-Murtada, doesn't mean that it's accompanied by circumstantial evidence in the time of Sahib al-Ma'alim. And that's what Sahib al-Ma'alim is saying. He's saying that we don't have any choice anymore. Murtada was saying we have a choice because all of these hadith are accompanied by circumstantial evidence. But Sahib al-Ma'alim is saying we don't have that anymore. We don't have these qara'in anymore because of the loss of written sources. We need a new way of evaluating this material. Um, and then, as you move forward in the tradition, you have other kind of answers to those questions. But um, yeah, that's what we'll say.
No, thank you very much. That's a very good point, and I think it dovetails nicely or segues nicely into the next question from the audience, which is, what is the difference between guidance and law? So, previously, in response to an earlier question, you drew the distinction between referring to the Quran as a source of guidance and referring to the Quran as a source of law. And so this ties nicely in with the distinction you're making in sort of al-Kafi, that Sharif al-Murtada, when we talk about mahfuf bil qara'in, we're talking about something that is, ultimately a legal text. So, could you perhaps elaborate more on what you meant by that distinction between guidance and law?
I mean, what is the Quran? In the end, what is it? It's nur. In the Muslim conception, it's ifadat an-nur. It's the unfolding of the divine light onto the heart of the Prophet. A metaphor. At one time, I think I heard it from Sayyid Munir Khabbas, is that that light is, you take the metaphor of a light being shined into a prism, and then the prism refracts that light into an array of, into the spectrum. Roy G. Bibb, I think we call it. Uh, uh, okay, so in the metaphor, the light is, the divine light pouring forth from the divine being. What's the prism? The prism is the heart of the prophet, and the heart of the prophet refracts that light into an array of knowledge. This has nothing to do with reading, right? And so I guess what I would say is that guidance is broader than not just law, but broader than reading. And law, for instance, if the, as we said, if the Quran says, ahallallahu al-bay', God made commercial transactions lawful. What can you do with that? What's the consequence of knowing that that verse is in the Quran, right? And that might be a legal question. Or even aqim as-salata, establish the prayer. What's the consequence of that? Which is different from the the much broader idea of the Quran as nur, as light.
Yeah, thank you. So
Does
I
that
think,
make sense? I apologize. I don't. It's a difficult question to. It's a difficult question to answer. I hope I don't sound like I'm being dismissive of it.
no, no, not at all. I think I think a valid point there, that often when what we lose sight of in these discussions is that they are fundamentally concerned with the Quran as a legal text, on deriving a specific legal ruling from the text of the Quran. Either X is obligatory, or X is forbidden, or X is permissible. This is, I mean, this concerns, I wouldn't say a narrow scope, it concerns a limited scope of within guidance. It's almost like the difference between something general and particular. So no one's saying that these legal verses aren't a source of guidance, but um, I think it's also important to note that, as you pointed out, that there are thousands of verses there. A portion of them concern legal issues, but then there are other concern, for example, stories of prophets, moral admonitions. There's many different kinds of verses within the Quran, and when we talk about guidance, it encompasses all of those. And then when we look beyond the Quran as well, remember, of course, the Quran, it is the Quran that enjoins the faithful to follow the example of the prophets. So then you have the idea of the prophet as uswatun hasana, a good example. And so then the prophet's actions and his character, and they become a source of guidance as well. So if you to sort of interpret interpret your answer in that way, would that be
Yeah.
an accurate reflection of what you're saying?
Yeah, and we can add to that. لقد أرسلنا رسلنا بالبينات وأنزلنا معهم الكتاب والميزان, right? That there's three components to what's communicated. There is rusul with bayinat, there is the kitab, and then there is the mizan. Uh, somebody, I won't name them, but somebody whom we both know and respect, he said one time that, you know, you can argue until the end of time about what the Communist Manifesto means. You need Che Guevara to embody it, and then you can point to him and say that this is what this means.
I'm not sure I'm fully comfortable with that analogy there. Although I've also heard that question asked the other way around. So there was a Marxist professor giving a lecture on the Communist Manifesto, and someone asked if the Communist Manifesto could be compared to the Quran, which was and just as I sort of abhor the idea that the Quran is anything like the Communist Manifesto from a Muslim point of view, the Marxist professor was equally outraged. So. But I take your point. There's the idea, there's the message, and then there's the embodiment and the application of that message.
I think that's kind of essential in Shiism in particular, right? That
Yes,
we can argue about the meaning of mercy until the end of time, but you need somebody who embodies mercy, and then you can point to that person and say that's what mercy is.
and this is also related, of course, to the famous distinction drawn by Amir al-Mu'mineen alayhi salam when he said, he drew the distinction between the silent Qur'an and the speaking Qur'an. The idea of the text on the page versus the text as explained by its authoritative interpreter, but almost applied to specific instances. I'm conscious of time, and so we have another question from the audience. I think this might be this might be the last question we do. What is the relation? And it actually ties perfectly into what we were just talking. So I feel that there is a
Let's take both of the questions, because number 6 is, I think, an important one, and I'll try to address them quickly. But
okay. So
so if you want to read number 6, we can
I'll
talk
read
about
out
it really
number 6.
quickly.
Oh, sorry, I didn't actually see number 6. So let's do question 6. Motsky and co. So this is, of course, Harold Motsky, the hadith specialist, have never come and said that the Sunni hadith corpus is historically from the Prophet. The Quran being a document from the Prophet's era or within 20 years of him has as much academic support. So the problem of historical reliability remains. There is no hadith corpus that can be historically validated in the same way as the Quranic codex, the Mus'haf, has been. See Van Putten Sidki et al.
Okay, so a couple of things. One is that I never said that the entire hadith corpus has been validated, but Motsky and other people who have what I would say are empirical experiments, have run empirical experiments, have gradually, I think, shifted the burden of proof. So yes, of course, you still have to, in every case, evaluate it individually. But at some point, the kind of blanket skepticism that's applied to hadith is no longer, one can't simply presume it. That's one thing. The second thing is that, I think there's a problem in the way that we think about early sources. So it's a kind of a more complicated thing, but the way I can say it is like this: is that in the end, everything that you have is a narration. Sometimes there's an assumption that we have an early text and it's differentiated from something else, which is called a narration. But I'm happy to be corrected, but it seems to me that both are narrations unless you have a holograph of the original text, which I'm not aware that we do. Once we recognize that fundamentally what you have in Al-Kafi and what you have in a putatively early source are both narrations, then we can have a more productive conversation about dating that material. And and the third point is that, somebody like Sahib al-Ma'alim, he's not talking about historicity of hadith. He's talking about hujjiyah. He's talking about the evidentiary value of this hadith, which is a different question, because those hadith only have value in the first place because the same way that, the two witnesses, right? The two witnesses is something that, that in the context of, within the framework of Islam, that God has allowed you to use the testimony of two witnesses to settle a particular legal issue. That you should know with certainty. If you don't know that with certitude, if you don't have knowledge of that, then you have a problem, right? But if you know that with certainty, then the claim is not that the testimony of those two witnesses produces true knowledge. The claim is that the procedure is validated, right? Um, so yeah, the procedure is validated. So similarly, in the case of, this entire conversation that we've been having, it's not the same as a question about history. It's a question about the evidentiary value of particular hadith, right? And in that case, those hadith only have what is called in tradition hujjiyah ta'abbudiyah anyways. They are evidence, right? What's the framework for Muslims? The framework is that on the day of judgment, God asks you, why did you do this? Why didn't you do this? And in that context, you have principles like mu'adhiriya and munajjiziyya. You have something can be exculpatory, something can be inculpatory, right? And the point is that if if you were to cite this hadith as, well, I did it because of this hadith, and it's a non-renowned hadith, maybe it's true, maybe it's not true. But um, the point is that it constitutes evidence before God. Now that said, and this is a conversation that I had with Sheikh Alex a while ago. Um, I think it's we are material which has absolutely no basis in history. Is That's also not what we're talking about. We're not saying that hadith which have absolutely no basis in history could be cited as evidence in law. There should be at least, Professor Halak, he used to give like a mathematical schema for it. He used to say that if you have 0 to 1 and in the middle you have zero point 0.5, so, and this is just for the sake of illustration, don't take it too seriously, but I hope it explains something. If you go from 0 to zero point 0.1, then 1 would be knowledge, right? 0.51 to 0.99 would be dhan or supposition. Zero point 0.5 would be shak, and then 0.49 to 0 would be jahl, right? And almost all of the law is in that 0.51 to 0.99 range, and 0.89 is not the same as 0.51, right? It's not the same as 0.61 or whatever. And so, the claim on the part of the Imāmī jurists is that the material which is closer to 0.99, right? It's not going to be, maybe it's not zero point 0.9, but the material which is closer, dhan khas, a particular type of dhan, this is the material that we use for law. It means that, you don't know it with certitude. So that's the last point. And the last thing I'll say is that, you know, you know, in Urdu, you say, हमेशा दिफाई मौक़िफ़ इख्तियार नहीं करना चाहिए. Until when will you adopt a defensive posture? Other people should have to present some justification for their view too. And I think that, again, I never said that the hadith in toto have been validated for historical purposes. That has nothing to do with my talk today. But if we are talking about that, then I think one thing we can say is that we have conducted, several empirical tests, not just about the hadith, but as we mentioned, Sadiqi's article on the Quran, in its broad outlines. Again, broad outlines. In its broad outlines, the broad outlines of the Muslim literary sources, I think, have been confirmed by those tests. So what do I mean by that? I mean that there was a time in Western scholarship where, Islam was a 8th century invention. It was all back projected backwards. Broad outlines, right? There's somebody named Muhammad ibn Abdullah sallallahu alayhi wa alihi wasallam. He lived in the Arabian Peninsula. He said some things, and I mean broad outlines. So, so my point is that I think the burden of proof has shifted, and it's no longer the case that um, that Muslims need to adopt this kind of defensive posture, and that yeah, the positioning has changed. Again, we need to differentiate between what constitutes evidence in law and something which could be evidence in history. But again, the last thing, sorry to take long, but it's an important question. Um, Somebody who says that should also consider, somebody who says that, I think the underlying claim is that contemporaneous written sources are the only sources that count as historical sources. Well, there's a lot of sources that we don't apply the same level of skepticism that aren't contemporaneous written sources. And so, yeah, I would say that seems to be an unfair standard of evidence, and also because it misrepresents the process of the compilation of books. This is something that um, Lapidus has a nice section on in his book, where he talks about how books come into being. Anyways, I'm sorry for that, but I thought that question deserved uh, a thorough kind of engagement. I'm not saying I answered it in a way that would satisfy the person who asked it, but hopefully the beginning of a conversation. And then you said the seventh one, right?
Yeah, I mean, just to make sure I've understood you properly, what I think you draw an interesting distinction there between the discussion of historicity versus the discussion of authority. So that's not to say the two are completely separate, but it's one thing to ask what is the legal value of a hadith, or the authoritativeness of a hadith versus asking about its historicity is a separate but related question. And I think it also, I mean, you also, I mean, this has come up. You mentioned this before. We did have Dr. Saifuddin Kara from Groningen University here with us at iCare in person a couple of months ago, and we will hopefully get the recording of his lecture online soon. And he discussed sort of the isnad kam matan method of investigating these reports. And I think it's important to note that no one's suggesting that these methods of these sort of empirical methods of research necessarily prove in the scientific sense that a particular text came from a particular person, such as the Prophet sallallahu alaihi wasallam. But what it does is it establishes that these texts are from that period, as in they could have credibly come from that source, and they're to be taken into. I think they're to be taken into account with traditional scholarship. You mentioned Hasan Ansari. One of the most interesting short pieces I've seen Hasan Ansari do is on the sort of textual analysis of Ziyarat Ashura, which of course is a very important Shi'i devotional text about of which there are questions about its authenticity. And I think he made a compelling case that the contents of Ziyarat Ashura, which is supposed to have originated with the Imams alayhim salam, the contents of Ziyarat Ashura certainly suggest it came from the Umayyad and not the Abbasid period, which would match what we see in its isnads, going back to going back to the Imams rather than it being some sort of later creation. Now, someone pointed out to me, they said, yes, but that doesn't prove that it came from the Imam. And my answer to that was yes, but it does suggest that claims of it being a late fabrication are also false. It puts it in the same time zone as the Imam, and then we can take that as this could be taken almost as one of the qara'in, in a more modern sense, I suppose.
Yeah, and just there's another. I think it's important to clarify the question of Matsky. First of all, I'm not a historian of early Islam, but that said, Shiites don't need to trace material back to the Prophet, right? If the material can be traced back to the middle of the 8th century, which is probably, from a historian's point of view, the earliest it can be traced back, then that's sufficient for Shiites. Um, so, let's also not think of history as some kind of mother science that solves, every issue. History has its role, and if it takes you back to the middle of the 8th century, then that's great. Then other disciplines, other branches of knowledge can do other things. So, whether or not Matsky has traced a particular hadith back to, my understanding of the dating of the material relies on, Najm, Haidar, and some other people, and it seems like to me that in general the material can be dated back to the middle of the 8th century at earliest. That doesn't mean that all of it dates back to the middle of the 8th century, but at earliest, which is sufficient for Shiites. Which is sufficient for Shiites.
One of the benefits of having a line of successors to the Prophet, of course, is that you have that almost that extended period in which your sources your source is preserved invaluably. So that's very that's something that always struck me as well. I'm conscious of time.
Sorry. So, for somebody who says that one ought not exaggerate the contribution of Matsky, I would say one ought not exaggerate the function of historiography.
Touche. Um, so on to question 7, which will be our last question for the evening, and before we draw this to a close, what is the relationship between the Qur'an and the Imam? If the Qur'an is essentially a light, then is that light also embodied in the Imam? Can the Imam abrogate a ruling in the Qur'an? I feel that this question is above our pay grade, but I mean, perhaps we can reframe it as in the thought of classical Shi'i scholarship. What is the thinking on this?
Um, so the relationship between the Quran and the Imam is that the Imam is the embodiment of the Quran, just as in Sunni tradition, when Hazrat Aisha is asked about the character of the Prophet, she says "Khuluquhu al-Quran," that it was the Quran. And just as in West Africa, when there were abolitionist movements, they argued that the people who had memorized the Quran embodied the Quran, and so to enslave them was to desecrate the Quran. The Imam is the embodiment of the Quran in the same way. If the Quran is essentially a light, then is that light also embodied in the Imam? Um, you know, maybe I would need to think about that a little bit more carefully to answer it in a good way. The question of whether or not the Imam can abrogate a ruling in the Quran, again, it's not something you know. In the end, I'm a historian of thought, so my response to this has to be that in Ma'arij al-Usul or Mu'tabar, I can't remember which one, Muhaqqiq says no, that cases of abrogation end with the death of the Prophet, if I remember correctly. So that doesn't mean that subsequent jurists have not said that. And also, it also means that one has to have a correct understanding of the idea of abrogation, right? Simply maybe some things which are bound by time and place from the beginning, if they change, that doesn't mean that they've been abrogated, right? So cases where an imam does something that's different from, let's say, what the Prophet did, aren't necessarily uh, you know, there could be cases where the original rule was bound by time. There's a hadith in Nahj al-Balagha where somebody asks Amir al-Mu'mineen why he doesn't dye his beard red, and he says that, well, in the time of the Prophet we dyed our beards red, and he replies that, in the time of the Prophet we were a small group, then we didn't want people to think of us as weak, and so we dyed our beards red so we wouldn't look old. But today Islam is an empire, there's no danger of that anymore. I mean, that's not a case necessarily of disagreement. And for there to be a true abrogation, and I mean, that's not a case of abrogation, but for there to be a true abrogation, there would have to be a real conflict. Um, so that's what I'll say about that.
Yeah, no, thank you. And just to sort of add my own 2 cents, like a thinker I'm familiar with, Faith Kashani, who's a very famous Safavid thinker. He's a philosopher, a mystic, a scholar of traditions, a commentator on the Quran. In his introduction to his Quran commentary, As-Safi, and also the abridgment of that, Al-Asfar, which I translated, there is, he makes the very important point that in his mind, the Quran and the Ahl al-Bayt are two branches of the same light, and so it makes sense that one clarifies the other, and furthermore that there shouldn't be any conflict between the two. Quite the opposite. So there's this idea of this common source, and that source, of course, being the light of divine guidance, which manifests in different forms. And so that's an idea that found sort of sympathy amongst I think Shi'i thinkers, that there's this real almost ontological relationship between the Quran and the Imam. Although I think there are others who would perhaps frame it differently, but there's certainly that relationship there, and I think maybe that's something we can explore in a future seminar, perhaps.
Yeah, for sure. If we're concluding, there is something I'd like to say before we kind of finally conclude. And first of all, I just want to thank you for the opportunity. As I said, the research for what I presented to you today was conducted in collaboration with uh, Hassan Ansari, who really is, an ocean of knowledge. Um, and any mistakes that I made are are mine. They're not. They cannot be attributed to Ansari. And then, the other thing I'll say is that, if I said anything incorrect or made mistakes or things like that, then I would ask that the audience overlook those mistakes, and inshallah, and email me. Email me if you have some corrections or comments, then email me. إن العصمة لأهلها.
Uh, thank you so much, Professor Aun, for joining us. It's been a real pleasure to have you here. Thank you for giving us so much of your time and for presenting this really sort of detailed research on a key question in Shi'i thought, and addressing the sort of this range of questions we've had. Certainly, we'd love to have you back for another one of these in the future. And I think I speak on behalf of everyone here, all of our viewers and all of the team, when I just say, we're really appreciative for sharing your knowledge with us today. So thank you again.